Hello, everyone. I'm Jay Lazega. Welcome to this installment of L&J Lazega Johansson's Morning Break. We're excited to have you here. We miss you guys, miss seeing you. It's been a long time, but we are back on track. We are excited to announce that we are not doing a session today on COVID. We just can't bring ourselves to do the COVID discussions yet, but we will be talking about in the next few weeks e-blast in a session on the 2022 season COVID protocols. Those will come up soon. For now, though, we're going to talk about contracts. We are approaching the time of year where we are starting or renewing many of our contracts for capital improvements, community maintenance and repair projects, and many other things. And contracts just universally are one of those things that get communities and that get individual property managers in a lot of trouble when things go wrong. And it's very often easy to prevent or minimize the chance of things going wrong on the front end with just some very simple things to keep in mind. So today's session is about tips and tricks in the contract process. We've got Rob Stein, Jeanette Shockley. Hey guys, welcome.
Morning.
And they're going to cover our discussion of contracts. I'm going to start with one thing. Many of you may have been in the Atlanta area for long enough to remember a radio show, Rob and Rob's Contract Show, on one of our local radio stations. And one of the Robs used to say, and they were contractors, talking about how things can go wrong in the process and giving advice to people. And they used to say, look, if you don't have something written in your contract, I'm going to screw you just for the sake of screwing you. If it comes down to me making money or me not making money and doing something that choosing to not do something that's not required of me in a contract, I'm going to not do it if doing it will make me to lose money on this job. Very important to keep in mind that while we may have great relationships with contractors, they're business people, and ultimately they are in this contract to make money with as little, the least work they possibly can. So our job in this process is to try to go into the contract process in both making the contract, enforcing it, getting out of it in a way that recognizes we need to protect ourselves and be very specific about what we want. Okay, so Rob and Jeanette are going to talk about that. A couple of very quick administrative things. You guys have done these sessions before. You, I believe, are familiar with the menu bar, whether you're on your computers or your phones or mobile devices. There is a function for you to ask questions. And we may not get to all the questions today. If we don't, we'll reach out to you and try to get with you guys individually. But we want to hear your questions. Type them into your question area. We actually also love just hearing your hellos and well wishes. But type your questions into the question section, and we'll try to get to those if we can. We also love hearing your suggestions for topics for our programs. So type those into the question area also, and we will look at those and maybe make future programs for those suggestions. We also are going to reward you guys. So for those of you who ask questions or give us suggestions of programs, we're going to pick 5 random lucky winners to win one of these awesome Lazega and Johansson Arctic coolers, which are awesome. They keep food cold for like months. So these are fantastic. We'll pick among the questions. And then last admin reminder, visit our website, ljlaw.com, the resources section, a ton of information that you can use and share with your boards, forms, samples, articles, covering tons of things. So visit us there and feel free to grab and use what we have there. We're going to let Rob start. So Rob, I'll turn it over to you.
Good morning, everyone. When we were preparing for this, we've looked at thousands of contracts over the years amongst us as a group, and we kind of sifted out really our top tips to help and as you enter those contracts and need to exit the contracts and enforce the contracts. So let's get started. The first tip is most contractors are going to hand you their contract. And let's take one quick step sideways or back. Two major types of contracts we see and you see. Service contracts for things like landscaping, pools, pest control, cable. Project contracts, work contracts to do work, roofing, siding, paving, painting, renovations, name it. So those are two major categories of contracts. And so if you're working with a contractor, they will usually have their form contract that their lawyer has created that has provisions in it that help protect them. And they will hand it to you and hope you will sign it. Don't do it. You want to, not that anybody's a bad person, but as Jay said, everybody's out there to help their business. And so we're going to have some things here so that when and if things go wrong or the work isn't going right, you've got some protection for that. So number one, don't sign their contract. Tip number two, you may, who is this person who's in front of you? You may have worked with them before, you may not. They may have come by a recommendation or off a list. Old words from many years ago, trust but verify. Do some vetting. Make sure that other communities have had happy outcomes with it. We'd recommend that you get a referral, a recommendation from someone for work done recently and work that was done maybe 6 months to a year ago, so you have kind of a range of where the work is completed and down the road a bit. And so if something's gone wrong somewhere else, you may be able to see it. Tip number three, details. Details will save later arguments. Get as much detail into the scope of work. You need a good scope of work. If this is a roofing and siding contract, then we need all manner of details attached to the contract so that everybody is clear on what needs to be done. And for things like that are more sophisticated, we may need an engineer or architect or someone who's a professional outside to put that scope of work together so that it is detailed step by step, so that, again, everyone is clear about what was supposed to be done and what it's supposed to look like when it's done. Tip number four, be sure the contract states when the work is supposed to start. This one seems so obvious, but it often gets missed. You and the board are thinking that once you hand them that check for $10,000 for materials, that they're going to be out there day after tomorrow to start work. Well, the contractor is thinking that he's going to be out there in 6 weeks, and he thinks this is a 2-month job, and you're thinking it's a 3-week job. Well, he thinks it's a 2-month job because he's got 4 other jobs going, and he's juggling his crews between all of them because he's trying to keep everything running at the same time. Start dates, time for the work, end dates, at least anticipated ones, should all be in the contract. Tip number 5, include a payment schedule that's tied to the work. If we're doing roofing, let's look at paying them as different roofs are completed. And once the engineer signs off, if you're involving an engineer on the work, having definitive points of payment will avoid somebody pestering you on a Friday afternoon for a check when it's really not due. Having it in the contract makes it clear. You can very easily say, I can't pay you till this particular set of work is done. Tip number 6, stay ahead in the payments, meaning that let the work be further ahead than your payments. Let the work, you want to make sure that you've got the funds and the work is a little bit ahead. That keeps everything running a bit better. Tip number 7, include a warranty in the contract. Don't assume there's some warranty by state law, because there's typically not, that's going to apply. You want to have a warranty in there that says for labor and materials how long a warranty how long the work is guaranteed to be in good shape for. Tip number 8, protect the association, the board, and yourself. And how do you do that? Make sure you have the full and complete name of the association in the contract. We see many contracts over the years where the contractor doesn't really know the full name of the association. So he puts your name in as the manager, or he puts the management company's name in, or he puts a board member's name in because that's who they've been talking to. And that person then signs the contract, and the contract is between the contractor and that board member. This happens more often than you might think. Make sure you get the full, complete, correct name of the association in there. Relatedly, get the full and complete name of the contractor. Get their, if they're doing this under their corporation, make sure by going on the Georgia Secretary of State's website that you check off on you have their correct name. Because again, when things go bad, we want to make sure that we're having to chase after the right folks and the right name, not some other name that we are kind of stuck and can't really do what we want to do. So with that, let me turn things over to Jeanette.
Thanks, Rob. So when Rob and I were preparing for this webinar yesterday, we kind of joked initially that this is kind of like vendor Tinder, you know, if you swipe left or swipe right on the contract. And really that analogy just makes sense, because what a contract is a written relationship that you're establishing with a vendor. And the nice thing about the written relationship is that you can write how you break up. So when you come to the termination provision, one of my tips is that's the first thing that you should review before you get into a contract, because you want to know, hey, if I get stuck or I'm not happy, something happens, the board changes, and they just feel like they want a new landscaper or, you know, a new pool company. How easy or how hard is it to get out of this contract? And a lot of times, you know, when a vendor is selling you on a contract, they're gonna highlight all of the good things, but the termination provision is usually one that doesn't get mentioned. And I definitely would encourage you to look at it, because you want to, ideally what you want to see is a termination provision that says, I can terminate for whatever reason. I don't need to give you cause as to why I have to terminate. I can just tell you it's not working. And you want a short time period of notice. So, you know, maybe terminate on 30 days notice or 60 days notice. Ideally, that's the best termination provision for associations to look at. You know, the kind that you want to avoid are ones that say, you know, we automatically renew, and if you terminate at a different time, you'll have to pay the remainder of the contract fees. You want to avoid ones that say you can only terminate for cause. And what that cause is really kind of one of those things that lawyers and people argue about all the time. You never know if it's good enough cause or not. So, you know, let's say you have a landscaper that does a great job, but one fall they blow leaves onto the board president's lawn and don't pick them up. The board president calls you and says, I'm ready to fire them. What do we need to do? This is, you know, is that cause? Is that a reason to terminate? You know, is it a good enough reason? And a lot of times you'll end up arguing over that. And it ends up being something that gets argued about in court. So you want an easy exit strategy. Even if the relationship is nice and sunny and rosy, you know, there's always a honeymoon period. You want to think about what it's like when you break up. So next tip is checking insurance. Not only do we want you to check to make sure that the vendor that you're doing work with is properly insured, but what we go a little bit of a step further. I would go straight to the insurance carrier and ask them for proof of insurance. You know, the insurance carrier is the person that's ultimately going to pay the money out to the association if something happens. I want to know that essentially the company holding the purse strings is going to pay out. And they're going to tell you, hey, this policy is still good, or this policy expired. You know, they're going to give you indications that there are, you know, red lights or green lights when it comes to whether or not a contractor is properly insured. And I generally, with insurance, you know, there's the old saying about the word assume. Don't assume that, you know, the certificate of insurance that they've given you is valid or that they've paid the premiums on it. You know, the best way to make sure that you've got coverage is to hear it directly from the company that's got the money. So I would ask the insurance company directly, and most vendors won't have a problem with this. The next piece is indemnification. That's just a very long legal word That means, you know, if you get in trouble, I agree to help cover your legal fees. I agree to pay for damages that you do. Basically, I've got your back provision. And in general, you know, when you're doing work with a contractor, the contractor should be the one that is indemnifying the association. So they should say, you know, I'm sending people onto your property to do work. If they damage the association in any way, if there's an injury to someone caused by their crew or their subcontractors, you know, they are going to cover that for the association. They're going to cover the defense and the damages for the association. There are some contracts out there where the contractor actually has a provision that the association will indemnify the contractor. That's a red flag. You obviously, I would definitely say don't sign that contract. Ask for them to remove that provision, because ultimately, you know, a good vendor is going to want to stand behind their people and the quality of their work. And one of the ways that they do that is being willing to indemnify the association for the work they're about to perform. You know, the association doesn't need to not only be paying the contractor for the work they're doing, but also paying when and if they mess up or they injure, you know, the association or the property. I think all of those things kind of give you a good idea of what makes solid protection for the association on the back end. Another tip on the back end, when your contract is resolved and you're going to make the final payment to a contractor, get a lien waiver. And for those of you that don't know what a lien waiver is, it's really just a very special piece of paper where the contractor says, you know, I've paid my subcontractors, I've paid, you know, the material men that have provided, you know, whatever materials you needed to conduct the project, and I've paid my laborers. What that piece of paper does is then says to everyone that was involved in that project, the association has paid everything. You can't come after us if for some reason the general contractor didn't pay you. You're going to have to go after the general contractor directly. And I have a quick little anecdotal story about that, but you know, we had a community that did a paving project that was about $30,000, and they submitted the final payment, all the work was performed, and the general contractor took the $30,000, didn't give them a lien waiver, and then quickly disappeared. And the subcontractors and the material men who provided some of the materials that they used to complete the project then filed a lien against the association saying, we've not been paid for our work. The association ended up having to settle that with the material men who provided the materials to pay them, and then had to go after the general contractor, not only who they'd paid 30 grand to, but who they now needed to get, you know, the settlement amount back for what they'd paid to the material men. So you want to avoid that. You want to essentially make it so that those subcontractors, laborers, material men have to go after the general contractor and not after the association. Because if they're going to choose someone to go after, you know, the association is definitely the easier one to get money from. You're not moving around, you're not going anywhere, and you have property that they can put a lien on. So ideally, you want that lien waiver when you submit your final payment. And then my last point has to do with the dispute resolution process. So you want to look at what happens if there's an argument during the contract. What do you need to do? You know, do you need to give notice of a dispute within a certain time period after an incident happens? Do you need to mediate before you go to court? Can you go to court? You may have to arbitrate. If you can go straight to court, where can you file? Many contracts will have a venue provision that says you can only file an action against this vendor in a certain area. So quick example of that is I had a contract I reviewed the other day where the vendor is based in Florida. So the contract requires the Georgia Association to sue the Florida vendor in a Florida court under Florida laws. So that's making it pretty difficult for them to, go after someone that's in another state. And the law may be different than what we're used to here, so they may be treated differently. So in summary, those are just our quick run through tips of ways to make sure that, you get into a good written relationship with someone and don't have a bad breakup.
Awesome. Thank you, guys. We got a lot of fantastic questions, and we will definitely not be able to answer them all now, but a couple of repeating ones that I think we can do really quickly. When should we engage the lawyers in this? Frankly, I think you always should. Certainly for service contracts, but even we have a lot of communities say, look, we're hiring a handyman, just small jobs. Even then, the smaller the contract, usually the quicker and easier it is for lawyers to help with. The more involved the work, the more involved the contracts. I think you always use your lawyers. Just makes sense. All right. What Jeanette talked about, lien waivers, extremely important. It's really it's two separate things in one document usually. You want lien waivers, but the lien waiver really is your contractor saying, I waive my liens, I release you, I've been paid, and I won't file a lien against you. The second part of it is a payment affidavit, and this is huge. Subcontractors and suppliers can come after us even if we've paid the contractor everything, if they haven't been paid by the contractor. The payment affidavit is the contractor saying, I have paid them. The beautiful thing in Georgia is that even if the contractor's lying, as long as we don't know, we're protected. So you need to make sure that your lien waiver has that statement, I have paid everyone. How do we best protect against issues with contractors? Stay ahead of them in the money. It's hard because a lot of money, contractors want money up front for materials. If we can get payments following delivery of materials, and then we have more money than work they've done, they're going to come back and finish. If they have more money than work they've done, they're not going to come back and finish. Very simple. Of course, there are exceptions, but that's just generally what's going to happen when things go wrong. What if there's no termination provision in the contract? If we sign a 2-year contract and it doesn't say we can terminate, can we get out if we're unhappy with the work? Very important that you have very clear provisions to allow you to get out, because the law makes it really, really hard to get out if you don't have that. So that is an absolute must in your contracts. Liability for damage. What if our painter accidentally spray paints every car in the parking lot, or it's a windy day? Can we be liable for it? Potentially, yes, which is why we really need to make sure that we've got clear insurance coverage and clear indemnification provisions. It is still our job being done. So we're responsible to the owners for the quality of that work. And then last, payment schedules. A couple people asked, can you just give us samples? There really aren't samples because jobs have different time frames. But if you can, just make your payment schedule not tied to dates, but tied to the amount of work performed, so that we will only pay you up to 50% of the job after you've finished 50% of the work, or we'll only pay you this percentage of the job after you've completed this section of work. Huge protection for us. All right, for all the other questions, we'll try to reach out to you guys, or of course, reach out to us. We love hearing from you. We're happy to help you. We miss you guys. We hope we get to see you soon. Thank you for joining us, and we will see you next time. Thanks, everyone.